Dean of Sponsored Research, Professor Dasgupta, Dean RJSOP, Professor Vibhuti, and my fellow colleagues in the Patent Drive and dear students. I will be talking about the process of search and why that is important in preparing your abstract, and also the invention disclosure form which will be done post the abstract review. So just to take you a bit into the need for patent search, the importance of it, and the scope of what is patent search. Patent search is integral process of any patentability exercise in relation to inventions. What does that mean? That is, it is the very first step that you should undertake before you decide on filing of an invention. Okay. Now, how does it helpful to you? Let me tell you that in your research work or your project work, it is always good if you can include a search in relation to your area. So when we talk about search, we use the term called prior art. What is the prior art? That is, prior to your invention, what is known in that area? What is known in the area prior to your work? And how is that important? That is important because it distinguishes the old to the new. Okay, so if I have to say that your invention is new, I will base it on the prior art search that I do in relation to your invention. Okay, so when you submit an abstract, I assume that as though we are on a filing date, and then I look at the background data that is available in the literature. So prior art is of two different types of categories. One is called patent literature, the other is called non-patent literature. Okay, and in this two type of prior arts, patent literature is always on the higher index. Reason being, patent documents are represent technologies which are very novel, and they also represent an advance in technology. So the first thing that you should do before when you are ready with, let's say, the invention, please conduct a patent search. How would that help us as reviewers? Is that when you do a patent search, we know which is the closest to your invention. We get an idea about what is the technology that is as close to your invention as possible, because we need a distinction from that to your invention. Now, unless we are able to distinguish and say, yes, this is truly novel, we cannot proceed with the exercise of actually completing the review. To suggest invention should go for filing. So the fundamental requirement is to clear the novelty. Okay, and as Dr. Tapas said, it is also important to clear what we call eligibility. Just like we all take admission, right? We have to be eligible. Only then you join the institution. So every invention should also be eligible. So the law tells you that something is barred subject matter, something which is against public order, something which is in relation to agriculture, that is jurisdiction dependent. I will not go into that because I am dealing with patent search. So my suggestion would be, as a reviewer, is that please complete your search from the point of view of invention. How is this helpful? Because many times when we get the abstracts, and I am sure my fellow colleagues in this drive will also have the same opinion, it invariably goes to version 2. It invariably goes to a needs for improvement. There are really very few inventions that we say we flag them off as truly novel and go for immediate patent filing. Okay, so in order to hasten the process of the IP filing, cutting down on the review time will also help, right? So how would that help? That would help if you can at least be aware of the prior art in your area. Okay, you do not need to do the assessment. The assessment will be done by the reviewers, but you should be at least aware to what extent your technology is valid from the point of view of being novel. So the overall research in relation to bringing out novel ideas, novel processes and products can happen. Alright, so that's the basic premise with which I am now starting the view into patent search. So when we said that prior art is of two different categories, one is patent literature, the other is non-patent literature, and we usually depend first on understanding what are the related patents in this area. So you would typically want to know what are the patents. You have the WIPO database, It is called the patent scope. You may want to note down if you wish to. Patent scope is the WIPO database. It is available at www.wipo.int. Okay, and this patent scope database gives you the patents which are filed worldwide, particularly the international applications. So, you as students may be generally aware that we have what we call national filing and we have what we call international filing. Since patent application is jurisdiction specific, you can't have an international patent. You can't have a global patent. It is all jurisdiction specific. I have an Indian patent, I may also have a US patent, but I cannot have a global patent. Okay, so in order to streamline that, they have provided an easy way for the applicant to at least have a single filing opportunity, and that's what we call as an international application. Okay, where I file it at India and I'm as though I'm filing in the US and Europe and other countries. So that ability is there. Yeah. It is www.wipo.int. I deliberately did not give bring the patent search presentation because it's highly, we do usually for the patent classes at the law school, which will be, a little, go a bit overboard I thought, but I can share the presentation post my talk today. Okay, wherever relevant you can take it. Yeah, okay, that's good, thank you. And generally there are three major jurisdictions where we have a consideration when it comes to India. One is the Indian Patent Database. That's the official website of the Indian Patent Office. That is www.ipindia.nic.in. Okay, you can just type in Google Indian Patent Office and you will get the link. Okay, the other database which is useful is the USPTO, the US Patent Office link, which is www.uspto.gov. Okay, and EP, European Patent Office, you see a lot of filings in relation to patents. So EP, US and India is typically what you would expect. In fact, at this point of time, I can tell you there are 5 different countries in the world to which I told you about the US, Europe. There's Japan, where you see a lot of filing. And why are we interested in looking at Japanese patent database? Because we know that prior art can be existing in the Japanese patent set. Okay, so typically US, EU and Japan is where people search for. And now Korea and China have joined the game. Okay, so you see a lot of Chinese filings also, a lot of patents that China has filed. So they are called the IP5 group. They're called the IP5 group. And 70% of the entire world filing is actually with these 5 countries. That means all the novel technologies that we are talking about as novel processes and products, okay, those patent set you should be looking at. Okay, so, well, you can go to the Chinese patent database, but then you will have to translate. It's okay, you can go to Google Patents and pull out some Chinese documents. At least you can read the abstract and understand that. Okay, that's the thing. So, looking at patent literature is very useful. And how do you go about doing a patent search in the databases? It is done by what you call keyword. That is one basic type of search. It is the simplest of all. We in the context of the law school, when we teach students and build the skill in them, we also teach what we call the International Patent Classification Search. It's called IPC search. It is nothing but as though you are categorizing a technology into different areas. We have areas within each technology. Like you have mechanical engineering, you have manufacturing and design, you have CAD/CAM, like that. Every department has areas. So IPC is nothing but areas within the but I'm not going to bother you with the IPC search. Keyword search is going to be very helpful for you, where you can input keywords and pull out the relevant patterns. Okay, so for that, identify what Dr. Tapas said. The solution that you have arrived, you are solving, your invention is what? It is solving a problem in the prior art, right? So that you are doing by making some solutions. What is that solution? It is either a new process or a new product or a new system or a new method. So that you should search. That that specific one is what you should. So you can design keywords, and the inventor is the best one to design the keywords because you know the area very well. And many of these databases are actually quite good. They allow you to give even a phrase. So it is not that you have to only give the keyword and then you're missing out on something. The EP database is particularly good. The eSpaceNet database, which is the European Patent Office database. There you can give a concept search. You can just type in your technology literally. So you can get the patents. Okay, what is important after that is that you don't need to read the patent. Then we will not have many abstracts being submitted. So that is our worry. You read the abstract, that will give you a concise summary of the invention. Then that will let you know if your technology is really novel. Okay, so I think Professor Saha also has communicated many times that we are now to be moving into the next four of where we are very interested in knowing if there's some really core novel technologies available in the institute. And certainly there's a lot of expediting of the IP filing that can happen. Okay? So look at the abstract, that will help you in your research also to understand really where you stand with respect to what you think is the novel process or the product. Okay, that gives you a kind of a justification that yes, you are at the right thing. Because sometimes what happens is in the abstracts that we come across, we are really unable to decipher that. Okay, either because the inventor has not possibly given the entire information, or because some preliminary data is not actually provided. Okay, so it becomes difficult for us to match up that. Okay. So patent search is going to be useful. I will send you the slides for the how to go about with keyword search and all that. So inputting concept-based search is also available. Besides that, you have private databases also, which help you with a quick look at patents. Of course, we also do subscribe for some private databases like Questel Orbit database. We have Orbit, okay, and which is needs to be renewed. But in the professional context, when you look at companies and firms like that, where they do very professional way of looking at patents, they make it mandatory that you to provide a search document, because unless your technology is really very original, the ability to patent that will reduce. So it is like the higher the anticipatory value of your invention, the lower the novelty. So it's inversely proportional. The lesser the anticipatory value, the greater the novelty of your invention. So all the time we are worried about the first aspect of the novelty. If it is novel, then we can go into the non-obviousness inquiry. Okay, so this is something which is important to understand. So it would be good if you can become more familiar with at least the Indian patent database, the US patent database, and the EP patent database. It also helps you in your research because you know where you stand in research. See, many times what we do is we do a kind of, I believe we do a kind of context-based research. Someone has already done it, I do it in another plant, and then I call it novel. It's really not novel. So we need to kind of, look at that aspect of it. That's one thing. Second important thing is that how can the search be also understood from the point of view of non-obviousness? See, many a time there will be some novelty, okay, but the novelty value will not be very high. Reason being, the technology is known. But what is it that you have done? You have really customized the technology. You have really customized the technology such that the applicability of the technology increases. It is like we are seeing the same computer, the same system, then you are seeing a laptop, then you are seeing a palm top, then you will say it's a finger top. So, but then all of them are patents, right? So what is it? Essentially it's a computer you are running. So just to give you a very far-fetched example on that, I mean it's not really a good example, but to tell you that each of them is an invention. So sometimes customization of a technology is desirable and patents can be filed on that because they help in the application, realization of application. That is where we have what we call in India a reduced threshold in relation to non-obviousness. In the Indian Patent Act, you have the provision with respect to inventive step. That is, what is inventive? Something which is some technological advance. So if I say that I have made something, how would you assess that? You would say that yes, she has used some advance in technology. Yeah, it's a great invention. She's really applied, some level of ingenuity into the invention. So that's the primary consideration. But patents are also given where there is economic significance. Suppose I'm using the same material and I'm making it out of some leaf material and it is biodegradable. Though the technical advanced value is less, but it is on the inventive value, that is the economic value is higher. So under that secondary basis, also patents are awarded. So don't get disheartened in your prior art search when you look at patents that, this is kind of known, but I have actually, not invented a new process. Sometimes there is a customization. You might have reduced the number of steps, and thereby there is a different context defined. So then again, you can, look at, primarily it is not so highly novel, but then you have the secondary, on the inventive step, you can at least look at the possibility of it. So that is also the place where you would do patent search. So all of this, you can give it as supporting documentation in the abstract. So if you find there is a relevant patent that is closer to your invention, all you need to do is flag that, say it is a US patent so and so number. Don't even need to give any additional data. So quickly we can go through the review part of it. Because we also want you to make you aware that it is the novel technologies that actually can, the review process gets done faster if they are novel technologies. We have added difficulties sometimes in version 2 to bring in the predominant novelty in relation to any particular invention. So that's one part of it. The second thing is, it is not that all the novel technologies will lie only in patents. They will lie also in literature publications. Please don't think that the world is always locking the entire advances in research only in patents. It's not so. It's also in journal publication. So you have a wonderful central library link in which you have the entire documentation of research in different journals. Relevant to your area, please conduct a literature search. And that is what is called non-patent literature search. Non-patent literature search. And try to identify if there is any literature which is closer to your invention. Okay? And that will also help you understand to what extent you think your invention is novel. And I say this not to say that you should complete part of our job. When we give you the version 2, you will be a little bit, you will understand that, look, yes, I had come across this, and yeah, that is true. The reviewer recommendation is, certainly closer to what you are actually thinking. Because you are the inventor. Finally, you should approve the version 2. You should, address that. So, non-patent literature is something that you can get from the literature databases. And believe me, there have been many issues that we have been dealing with. For example, there was an issue of an IIT professor, working in a particular area, and Samsung has completely, patented that technology. And he says, look, I have a publication. How did they patent this? I should have been the prior art. So then, we get into the analysis of understanding that where is the overlap with respect to that professor's invention. So non-patent literature search is also important in relation to patent search. Now, how do you do non-patent literature search? Just the way you search for journal publications. You search for your area. Okay. How does it help you? Again, it helps in improving the originality of your work. And then, in the context of patents, it has to be highly original. You know that in publications, if you change the context, they will take your publication. Suppose they say, I worked in hibiscus, she will work in rose. Very good. You will get a publication. You will not get a patent. You will not get a patent. So that means the novelty value in relation to patents has to be really high. So since you are the inventors, you should get a real-time check on to what extent your technology is really novel. So to that extent, patent search is going to be very helpful. Okay, when we do as reviewers, this is from your end. When we do it as reviewers, okay, what is it that I am doing when I am looking at prior? I am assessing your invention. That is what we call patentability assessment in relation to prior art. So what is it that we do? We now take it further from your end and we look at the overlap between your invention and the prior art. So just to bring it in a more simple sense, suppose let us say we are talking about a chair. Okay, we are talking about a chair. The chair has an arm, it has a backrest. Let us say there are some specific features of the chair. And all that I am looking in the prior art is for that chair. The moment I get a prior art with all of that and I can make out the chair, the novelty is destroyed. That means your invention is not meeting the novelty requirements. Okay? That notion is something That can happen either with one patent application or it can happen with one non-patent application like a literature publication. So this is what you must be very careful about. Okay, and so the moment we get that complete overlap, we get immediately alerted. Then that is when we send it back to the inventor and say, is there something about this? Can you give us some more details? Where we can really rule out that yes, this is not going to meet the novelty requirement. So we give you a chance in the version 2. Typically, I'm sure if you ask any of our colleagues, they'll say we typically do not reject because we believe that maybe inventor might have missed some detail during the process of submitting. So we try to still try to establish if there was something which would have provided the novelty basis for the code. Okay. So that is where we look at the prior art. The second assessment that we do is, since we said novelty is not enough, we said it should also not be obvious. If it is obvious to your own colleague, then what is the novelty? I mean, what is so big about the work? So we are really looking at the ingenuity of your work. So that is when we combine different publications or different patents. You are not allowed to combine for novelty determination. For novelty, it should be only one patent or one publication or one place in the public. Even if few people in the public have used it, that will also amount to public knowledge. It is known. For the next one, which is not obvious, what we do is we combine a whole lot of information. There could be a public use, part of it is known that way, part of it is there in some other publication, part of it is there in other patent. So I can actually bring them together and still say that if I am bringing all these things, three things together, it is telling me that this technology is obvious. Then what we say is, if I combine, I am meeting the obviousness criteria. So therefore, this is not meeting the inventive step value. So that is the second criteria. So there are steps in there. So once we do that, we are more or less clear that, well, that is the stage when we know that yes, it is novel, and certainly to a large extent it is non-obvious. We then put it for a suggestion to, go ahead and file for a provision. Suppose your prototype is ready, we may also suggest a direct complete specification file. That is, the complete details of the invention may be filed. Okay? And like Dr. Tapas mentioned, utility is an important characteristic. Utility, though per se every invention will have utility, it will be good if you can mention the utility characteristic because it helps in the other process of where not only for filing general utility is enough. You should at least say to which area it will help in the improvement. But if you can give specific utility, that is useful for a separate process of technology transfer, which is where I think Professor Sahas looks at a lot of inventions. While you are patenting it, you know that the technology is ready. So you would actually want to go ahead and transfer your technology and not wait for the grant of the patent. So that is the thing. So patent search is integral part of the research. It would be, I am talking as a colleague under the patent drive, but the most important thing that every researcher in this room or every project student should know is that please conduct a patent search before you embark on any research topic, because you should know to what extent your work is actually going to be original. So from then onwards, you should plot the process. Most likely, you will really end up doing a very great invention. And I'm sure happy inventing, you should come up with, reviewers will have no work if you don't come up with good inventions. That's about it in short, I should say. I'll send you the slides. Yeah.
Actually, I had to ask you a question, and Dr. Kapil sir has also told